to?
I'm investigating a battery.
What's a battery? Battery of what?
You want to tell me what happened? If you're not involved, then start walking away before I lock you up. You're gonna get tased.
You are gonna get tased. I took off my shirt.
Put your hands behind your back. You're gonna get tased. Put your hands. Put everyone back. 1713 County. Taser deployed.
On October 5th, 2025, officers responded to a gas station to investigate a reported battery stemming from a road rage incident. Before analyzing the arrest itself, the threshold legal question must be established. What was the character of this encounter under the Fourth Amendment?
No, you're stepping outside. Come here.
Don't touch me. Don't touch me. Don't touch me.
Leave the room. Stop. Stop. Put your hands behind your back. Put your hands behind your back now. Turn around. Stop. Put your hands behind your back. You're going to get tased. We're not going to be playing these games. Right now I'm investigating. Time out. You came at me.
Don't walk up on me.
You came up.
Don't walk up on me. You got your body cam on?
Yes, it is on.
Okay. Don't play with me.
I'm asking a question and you're yelling. All right.
I said I don't want to talk to you.
Doesn't matter.
I don't have to.
You told me you were involved. All right. I am involved. I'm investigating a battery.
What's a battery? Battery of what?
You want to tell me what happened? If you're not involved, then start walking away before I lock you up. You want handcuffs on you? No, you're stepping outside. Come here.
Don't touch me. Don't touch me. Don't touch me.
Get back.
Don't touch me.
Put your hands behind your back.
Put my hands behind me.
Get back.
Calm down. Don't touch me. Calm down. Look, you interrupt.
All right.
You interrupt. Stop.
Put your hands behind your back.
Don't touch me. Don't touch me.
Don't touch me.
Some of the units now. Put your hands behind your back. I will stop once you put your hands behind your back. Put your hands behind your back.
No.
Now.
I said get off. What you want to shoot? I ain't getting nothing.
Who does that proceed right now?
He hit our head to the thing. To the head. It's in the side. Stop. You just kicked
Let go.
That's what I told you.
Under Florida versus Bostick, decided by the Supreme Court in 1991, a person approached by police in a consensual encounter has the absolute right to refuse to answer questions and to walk away. That right evaporates only when the encounter transforms into an investigative detention, which requires reasonable, articulable suspicion under Terry versus Ohio, decided in 1968. The subject verbally declined to speak with the officer and stated she had no obligation to do so. She was correct. Verbal non-cooperation, standing alone, does not provide the reasonable suspicion necessary to justify a mandatory detention. However, the officer had received a report of battery at that location, the subject had acknowledged her presence at the scene, and witnesses had identified individuals involved in the altercation. These facts, taken together, may cross the Terry threshold. When the officer initiated physical contact to remove the subject, the encounter crossed irrevocably from a consensual contact into a detention. That crossing carries constitutional weight regardless of what preceded it. The subject's sustained physical resistance pulling away, refusing to comply, and struggling against the officer's control activated a separate legal framework. Under Atwater versus City of Lago Vista, decided in 2001, physical resistance during a detention transforms the encounter into a probable cause arrest. Once the male companion issued a verbal threat of lethal force, the use of force calculus changed materially. Under Graham versus Connor, decided in 1989, the force is evaluated on three factors: the severity of the crime at issue, whether the subject poses an immediate threat, and whether the subject is actively resisting. With a second subject threatening lethal force and the primary subject still resisting, the officer's decision to deploy a taser falls within the intermediate force range recognized by the continuum. The deployment was preceded by a verbal warning and announced on radio per protocol, both procedurally significant. However, the subject had disclosed a pre-existing leg condition prior to the deployment. Under the Ninth Circuit's reasoning in cases addressing post-force medical care, officers must account for known vulnerabilities when assessing force proportionality. Deployment against a subject with a disclosed mobility impairment without attempting lesser means is a legitimate area of concern under the Graham analysis.
Get back! Stop moving! Stop resisting! Stop resisting! Stop resisting. Stop resisting.
Please call Reese. Call Reese right now. Call my attorney. He arrested me for no reason. He had no proof. Call Reese right now. I'm not playing.
Do what? Do what?
He sure did. He sure did.
Stand up.
Kick her in the face. You hit her face with the shot.
Stand up.
Stand up for what?
Stand up. I'm
Get
helping
off
you.
of me. I'll help myself up. Please don't touch me.
Do what? Do
You
what?
already kicked her in the face. He hit her face with the side. You kicked her in the face. He hit her face with the side.
Back him away. Stand up.
You did enough. I'm calling my attorney.
Stand up.
You did enough. I am an attorney. Why am I being arrested? Why am I being arrested? Can you tell me that? Why am I being arrested? Come get my keys. Come get my keys in my pocket.
Nobody's getting anything.
Yes, it is. My keys is in the car. She need my keys. She need my keys. My keys is in the car.
Hold on.
You arrested me for no reason. You kicked me. Get your elbow back. What the hell? Jay, stop.
Get in the car. Get in the car. Get in the car now. Good.
Stop, Jay, the kids.
Put him in cuffs. No, you're done. You're not listening. Put your hands on your back now. Turn around. Stop it. Put your hands behind your back. You're gonna get tased.
You are gonna get tased. I have to call my attorney. Get.
Put your hands behind your back. You're gonna get tased. Put your hands.
Put everyone back.
1713 County. Taser deployed.
For no reason.
Shut up.
You look her cuffs now.
No, stay there and be quiet for a minute.
I can't believe the thing.
Well, we can't believe you didn't listen.
I need water.
You're gonna need a lot more. Shut up.
I have physical condition.
You have a physical condition, yet you're being extremely confrontational.
Stop. Stop.
You should have stopped when I asked you the first time.
It was unnecessary.
You're unnecessary.
All right. Now you let my legs go, please. I can't breathe. I can't breathe. Can't breathe.
Sit him up.
Can't breathe. That's unnecessary. Dirt. Slow down, dirt.
13, what's
Slow
the
down,
fuck
dirt. That was unnecessary. Water.
We'll help you stand up.
I need some water. I need some water.
Don't worry about that.
I have a physical heart shot you with them tasers.
Hey, here's the deal. Fire department's here to check you out, so we'll move that out real quick.
What?
All right, go ahead.
Fucked up my leg. My leg already.
Well, what do you know?
That's what I'm saying.
Well, what do you
Listen, I have this left leg is already there.
Following deployment, the subject reported difficulty breathing. Officers have an affirmative constitutional duty under the 14th Amendment's Due Process Clause to provide reasonable medical care to an arrestee who reports a medical condition after use of force. The call to fire department for evaluation met that minimum standard. On the obstruction charge, obstruction statutes uniformly require a willful act that actively hinders an officer in the lawful performance of duties. Verbal refusal to answer questions does not satisfy that element. The factual basis for the obstruction charge rests entirely on the physical resistance, not the verbal non-cooperation, and that distinction is legally critical. On the disorderly conduct charge, under City of Houston v. Hill, decided by the Supreme Court in 1987, the First Amendment protects verbal challenges to police officers, including profanity, unless the speech constitutes fighting words or incites imminent lawless action. Profanity and refusal to cooperate directed at an officer do not clear that bar. The disorderly conduct charge faces significant constitutional headwinds. The subject raised an allegation of racially discriminatory policing, specifically that the officer sided with the white male complainant over her based on race, while the original aggressors, who had thrown a glass bottle and committed a physical assault, were permitted to leave the scene without arrest. Under the Equal Protection Clause of the 14th Amendment, selective enforcement of the law based on race is unconstitutional. Establishing that claim in court requires demonstrating both discriminatory effect and discriminatory intent, a high evidentiary burden. But the factual predicate she describes, aggressors flee, defender is arrested, is precisely the pattern that equal protection claims are built on, and it warrants independent scrutiny beyond this footage alone.
On three.
Now you gotta use all your muscle. Come on, help. I can't move. You gotta
You gotta put your foot on the ground, not underneath your ass. Bend your
All
knee.
right, you don't have to holler.
Bend your knee.
Don't grab me.
What's up, boys? We have.
How old's the kids?
I have a 1-year-old and a 5-year-old. They won't let me see the
Were you involved in an accident?
No, he tried to hit my car, but it don't even matter now. I'm calling my attorney.
Okay,
You just fucking you for no reason.
That's fine.
So I'm calling my attorney.
Listen, put
I'm
that
calling my father. My father is
that's
an
fine.
attorney.
That's fine. Put
So
that
please,
listen,
let your body cam footage
it's
please
on
roll.
body cam. Can you listen to me for a second?
Ain't nothing
All
to
right?
listen about.
Whatever just happened out here, let's put that aside for a
There
minute.
ain't no putting that shit aside.
You
didn't want to listen to me when you pulled up. You came aggressive. Because you wanted to be racist. You wanted to pick a side because it was a white man that called on me and I didn't do shit.
No, I don't know.
That's what you did. You came and slammed me by the door, grabbed me, then your homie kicked me in my fucking face. I'm a woman.
Okay.
Regardless of how you feel about me, I'm not race. I'm a woman. I have 2 kids in my car.
Were you involved in an accident?
I'm a fucking registered nurse. All I was trying to do was get some gas, go
Were you
home.
involved in an
No,
accident
I did not hit nobody's car. Nobody hit my car. He tried to crash
that's all I
into
want to
me.
know.
I'm going to that car to go put eyes on these kids and see how they're doing.
Okay.
If she has somebody that can be with the kids, is your sister here?
Yes.
Okay, can we sort that out? Because if there's 2 kids in the car at a gas pump, I'd like to that. I know you guys got a bunch of other stuff. I just want to make sure these guys are good.
So he was not here for any of this. He showed up after the fact.
Who is he?
That is the boyfriend of the sister, who was not in the vehicle at all. So the 2 sisters with the kids was in the car, and they pulled into the gas station. They probably didn't signal fast enough or whatever, but the car behind them started honking.
So is this a 1050?
So this is a road rage.
So she said they did not get into an accident.
Yeah, it's a road rage because the 2 sisters pulled into the gas station, and then they were wailing on the horn behind them, like, whatever, maybe they didn't signal fast enough or stop too fast. He gets to the male driver of the other vehicle, gets out, throws a glass bottle at the car. We've got damage on that vehicle and glass shattered all over it. And then the sister gets out who was driving, and the 2 male and female passenger driver get out and start whooping on the sister. She just tried to break it up. She never swung on anybody. She threatened to mace them.
She did.
She didn't swing on anybody. She broke it up.
Okay.
She threatened to mace them when they wouldn't stop whooping on the sister. So it was 2 against 1. She didn't hit anybody.
So who's the one whooping on who?
That would have been the sister got into it. They attacked her.
So them over there got cut.
The original caller,
Who's over there?
nobody was there. They left. So I think they're the ones that started it, and then they fled.
I need to lean on you. Because my hands is tied behind me.
Break my back.
Well, this is what I'm telling you. My leg, pull my pants leg, pull it up. It's f***ed up. Not because you need to understand this shit. So my leg is f***ed up real bad, right? So I can't just walk from this far distance.
They taking sweet baby Jesus away.
Let's check it out. They tased me for no reason. I did nothing wrong. I broke no laws. I don't know. Can I have a bottle of water? They didn't want to give me no water. They beat her up in front of me. They probably gonna try to kill me. Take a picture of me. Take a picture of me because they probably gonna try to kill me. They tased me, man, for no reason. Take a picture of me because they already demons, they devils, and I did nothing wrong. These men beating on her. She was bleeding. The motherfucker bastard kicked her in the face. I did nothing wrong. I promise. I ain't did shit wrong. Now how am I supposed to get in this? You got a bottle of water in your car? No. They don't even give me no water, man. So why am I being arrested for? For obstruction. Obstruction.
Because you came to our situated.
Yeah, don't just write that up. I ain't got no extension.
We're gonna write it up.
How am I obstructing when y'all tased me?
We're not going to argue here on the street. That's
Jay,
recorded.
Jay,
You right.
Jay,
Go ahead and sit down.
please.
Nah, don't worry about it. It's gonna be all right. I love you. They tased me.
Watch your data station.
Because my injuries. Who is your injury for me to take your shoes off? My feet. I can't walk. I got special inserts. I recently got a brace on my leg.
That's fine.
I can shake my leg.
That's fine. Do a general search. Faster we move, the faster we get them out here.
Okay. Yeah. You get out of here.
Now for grades. The female subject receives a B-. Her verbal assertion of constitutional rights was accurate and consistent. Her account of the underlying altercation, if accurate, places her as a defensive intervener rather than an aggressor. However, her sustained physical resistance during the detention attempt provided the factual predicate for the resisting arrest and battery charges she now faces. The legal remedy for a disputed arrest is the courthouse, not the scene. Secondary officers receive a B. They provided effective backup, maintained professional demeanor post-arrest, and conducted thorough witness reconstruction that produced critical investigative context. The initial denial of the subject's water request post-taser was a minor procedural misstep, and no secondary officer on camera challenged the primary officer's pre-taser escalation trajectory. Before closing, 3 takeaways this encounter makes clear. Second, officers must articulate the legal basis for a detention before initiating physical contact. Saying, "before I lock you up," is not the same as establishing reasonable, articulable suspicion. The failure to clearly communicate that basis is not only a procedural gap, it is the foundation of a potential Section 1983 civil rights claim. Third, when the original aggressors in an altercation are permitted to leave, while the person who attempted to intervene defensively is arrested, every element of that decision, who was questioned, who was detained, and who was allowed to go, will be examined under the equal protection lens. If the case reaches federal court, let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.